Commission resumes. Those who've been wondering why we took so long to resume, I can let you into a secret. Advocate Tekota celebrates his birthday today, and the evidence leaders and others contributed to a splendid birthday tea. So that's why we're back late. Those who missed out the tea, well, I think there may be some things left over for them to enjoy too, but I can't make any promises. You're still under oath, Mr. Jamison. Ms. Pillay, you're still cross-examining.
Thank you, Chair. Chair, if I may begin by dealing with the objection that was raised by Mr. Baum on behalf of Lonmin, and that's around the factual basis for questions that there was a perception that what was transpiring was a negotiation. And I can do no better, Chair, than to refer to Lonmin's own documents. It's quadruple E19, which is the Korea RDO occurrence book. And I know, do you have a copy of the occurrence book before you, Mr. Jamison?
No.
I suspect that it's not, yeah. If we can have quadruple E19 put up on the screen, please.
Your counsel says you haven't got it, but if you change your spectacles, you'll be able to see it on the screen in a minute.
Mr. Chair, I would have no difficulty if Ms. Pillay simply read out the particular line. I don't imagine it's more than that, and we can take it from there.
Chair, there's an entry on the 21st of July at 10 o'clock, and it records, and it reads as follows. RDO's first illegal march to the General Office Korea. Then the next line, first demand made for an increase from 5,400 Rand to 12,500 Rand. Next line, negotiations between VP Mike Da Costa. There we go. Negotiations between VP Mike Da Costa and Tumelo Nkisi and two reps from the RDOs. So you see that, Mr. Jamison, that even the...
There's an objection been raised. This is your answer. Mr. Bam, do you persist in your objection? The light
I do. It doesn't change the situation one bit, because what was put was a perception on the part of the workers. And we still don't have any evidence coming from the workers about their perception. This was a recordal in an occurrence book. We're still waiting to see where there was evidence that what is being presented as perception by the workers was in fact so perceived by the workers.
Chair, if I could just refer to the next entry on the 23rd of July at 10 o'clock, where it's recorded that NUM Yuasa AMCO informed and NUM not happy that they were not involved in the negotiation. So...
It doesn't deal with the point Mr. Bam raises. But have you got the extract from the statement of Mr. X, to which you referred earlier? Supplementary statement, which he confirmed under oath.
We do, Chair. If I can just ask Ms. Lupuana had it on a screen, Chair. She'll pull it up for us in a few minutes. I think in the meantime, Mr. Mpofu wanted to say something, Chair.
Mr. Mpofu, do you want to say something too on the subject?
Yes, no. All I wanted to add, Chairperson, was just apropos Mr. Baum's statement that I think it's quadruple P1, Mr. Nzuza did say that had the approach taken by Da Costa been adopted, and in comparison to what actually happened when he was involved, for what it's worth. So
he saw it as negotiation. He doesn't use that word, but
yes,
I must say that it seems to me that I think it's not necessary there should be direct evidence. I have in the past ruled in this commission that points can be put in cross-examination based either on statements filed or evidence, or something which could be inferred as a matter of circumstantial evidence. And it seems to me that inasmuch as the witnesses to whom Mr. Bam referred didn't give evidence as representatives of all the strikers, and if it was a reasonable perception that on the part of the reasonable striker, if such a thing exists in this particular context, then that what was happening was in fact amounted to negotiation. The point that's being put by Ms. Pillay is supported by a process of circumstantial reasoning based on circumstantial evidence. So the objection is disallowed. Ms. Pillay may proceed.
Thank you, Chair. Mr. Jamison, in the circumstances, I'm going to put to you that it was entirely inconsistent for Lonmin to engage in this process which we've just described through Mr. Da Costa towards the end of July, but then on the 10th of August adopt a completely intransigent attitude where it refused to entertain the demand of, or listen or entertain the demand of the workers for increased remuneration. So your response to that?
Can only repeat what I said, regardless of how it's seen from one side, from the side of the company, and I think I can say that because in the EXCO meeting where it was discussed, it was very clear between the conversation between Barnard and Mark Monroe that there was no mandate to negotiate. It was not negotiations. Be careful about these engagements over this grievance, and you clearly can't negotiate, going to one of my points, unless you had the whole bargaining unit's agreement, and in that case Mike DaCosta would not have been the principal, it would have been someone higher. So all I can say is that from my perspective, my view, is this was not negotiation because it didn't meet quite a few criteria that would have classified it so.
And in view of the perception that we've dealt with already, Mr. Jamieson, what I'm putting to you is that the situation was exacerbated by the fact that Lonman was well aware that they were well aware of the shortcomings of the collective bargaining structure, and we've had extensive evidence this morning to demonstrate that middle management and EXCO were aware of the significant shortcomings of the collective bargaining system that it employed, and that this system didn't cater for the situation which Lonman was dealing with, namely a large percentage of its workforce being either non-unionized or being represented by a union other than the majority recognized union.
Yes, I think that was your third point when you were talking about between April and July. And I sought the clarity that when you were saying about the system, that it's underlaid by a legal agreement. And so regardless of whether we think that the effectiveness of that agreement is waning, we are still bound by it. And therefore the approach from the EXCO is, regardless of our opinion on it or anyone else's, we're bound by that legal agreement and we have to operate to it. That's my understanding.
On the question of the binding nature of the legal agreement, Mr. Jamieson, were you aware that at the time NUM would have considered engaging in discussions outside the collective bargaining structure if that meant exploring ways to bring in a peaceful end to the turbulence experienced at Lonman?
Was that between April and July?
That's
July
correct. The evidence before this commission is that NUM would not have been averse to engaging in a process outside of the collective bargaining process if that meant that it would bring an end to a peaceful end to the strife at Lonman.
No, I wasn't aware of that.
And what I'm putting to you is that Lonman EXCO was aware of the possibility of acting outside the collective bargaining structures, and that in fact had it pursued that possibility, as we're saying it had a duty to do if that meant bringing a peaceful end to the strife at Lonman, that it would have discovered that NUM was in fact open to that, notwithstanding the agreements which you refer to.
Okay, but there was no strike by the 18th of July. You were referring to the period between April and 18th of July.
No, I'm referring to the period in the run-up to the demand on the 10th of August and what had transpired afterwards.
Okay.
That during that period, NUM would have been open to opening up discussions outside of the collective bargaining structures if that meant
Yes.
bringing in a peaceful end to the strife, not the strike, to the strife at Lonman.
Okay.
Yes.
Yes, no, I wasn't aware of that.
And in view of this possibility, what I'm putting to you is that Lonman had an obligation to explore whether or not it was possible to do so, and that Lonman failed in that obligation.
No, I wouldn't agree with you. The analogy I would draw is that a group of people had been to the court of Mr. DaCosta. Mr. DaCosta had consulted with his fellow people and gave an answer at that level, and the answer was no. The people who received the answer weren't happy, so they wanted to go to the appeal court. The appeal court is Mark Monroe, but Mark Monroe was part of the decision, and there was no grounds for appeal. So therefore they decided, let's march to the appeal court and demand to see some judge that'll hear us. And that can't happen. So we fully dealt with the matter at the time that Mike was engaging in these discussions which were exploratory, which he was entitled to do with his employees in order to try and clarify what was at the bottom of it. And there was a good debate. As you saw, the risks were weighed up. A judgment was given, and that judgment was communicated back to the people who had come there. There was no further obligation for us to receive any more grounds for appeal, if you like, because there was no change in the circumstances, and we had done what we thought we could do.
Well, what I'm putting to you is that in view of how Lonmin handled the demand in July, and in view of Lonmin's accepted understanding of the limitations of the collective bargaining structures, that Lonmin had an obligation to pursue all avenues in order to arrive at a peaceful outcome. And if those avenues entailed exploring systems beyond the collective bargaining structures, then Lonmin had an obligation to do that.
If you could identify each avenue and each obligation, I could answer that, but generally saying we had obligations to consider all options, I'm not aware of what other options there would be.
Well, the specific one I'm going to refer to is to deal directly with the strikers, to understand what was the cause of their complaint and whether it could be dealt with constructively.
Yes, agreed. And Mike DaCosta did that, and they received their answer.
Beyond the decision to give a 750 Rand RDO allowance, that Lonmin had an obligation to try and explore every avenue to ensure a peaceful outcome, even if that meant going outside the collective bargaining structures.
When you say a peaceful outcome, there was no, up until the 10th or 11th, there wasn't any unpeaceful activity. So are you referring to the 10th? Or?
I'm referring to what occurred after the 10th.
Well, after the 10th was not peaceful.
After the 10th, did you not have the police actually saying to you, we have a problem, and they want to speak to you, the strikers on the Kopi? They had taken the trade union presidents there in a Nyala, and they negotiated with the loudhailer from the Nyala. So from a safety point of view, there was no danger that whoever went to the Kopi could be injured in any way. The police, according to what we heard, were anxious that you should make some gesture. But according to the evidence, Lonmin's dug in, had taken up a position set in concrete, as it were. They weren't prepared to budge, and they gave reasons as to why they weren't prepared even to go to the Kopi in those circumstances to speak. They weren't prepared to receive representatives from the strikers, although the protocol that exists in Lonmin for dealing with an unprotected strike provides for that. Attitude of Lonmin was just niet the whole time. That's the thrust of the point being put to you, and that's correct, isn't it?
So post the 10th, yes, most certainly. And I was hearing those discussions between Mark, Barnard, Natasha, A.B. Kotler was on certain calls after that as well. And they were taking all the issues into consideration, and that was their stance. I had no grounds to object to that or question them on it. I've got a principle that I think the people who are there dealing with the situation and on the ground, they need to take that decision.
The policy decision they took, in fact, amounted to a departure from the protocol, the Lonmin protocol, for dealing with unprotected strikes. That's correct, isn't it?
I don't know, Mr. Chairman.
I'm sure Ms. Pillay or one of the others will take that point up.
Mr. Chairman, I'm certain that one of the other parties will take the point further. I'm running out of time, so I need to just move to a new topic very briefly. And if I can ask you to look at quadruple V 1.1.
Running out of time, we may have to revise the time allocation. I understand that the SAPs are available to cross-examine, is that correct? How long did we give SAPs?
Chair, there's been a slight change. SAPs have an hour, but when I requested earlier, they hadn't made a final decision whether they can go this afternoon, but Mr. Mpofu has said he can certainly take up an hour of his time this afternoon.
how long have we allocated him?
He has 2 hours.
2 hours. So if we work backwards, an hour, Mr. Porford, means he would start at about 2:45.
That's so, Chair.
And are the police not in a position to cross-examine before 2:45?
Chairperson, I don't think I'll take more than 10 minutes. I would be in a position to cross-examine.
Right, so we'll give him a quarter of an hour on that basis. That takes us to back to 2:30. So is there anyone else who's in a position to cross-examine?
We've received no indication of anybody
All right, so
else,
on that
Chair.
basis, I think the sensible thing to do is if Ms. Pillay has got questions that she wants to ask, we will allow her to cross-examine until 2:30.
I'm indebted, Chair. If we can then look at quadruple V 1.1.
Which page is that? Please?
It's page 1 of the bundle.
Page 1.
And the email that I wish to deal with, Mr. Jamison, is the one that appears towards the end of the page. It's an email from you to Mr. Tibedi Ramoncha from the DMR. It's dated the 12th of August 2012, and the time is at 1:06 in the afternoon. Do you see that?
Yes.
Now, in that email, you give a summary of events, and you rightly say that you are concentrating on speed of communication and that you're unsure of accuracy, so we won't go into how accurate your account of events are.
Yes, and there were a couple of errors in there.
Yes. But what I would like to raise with you is what you say on page 2 of the bundle, in paragraph 2, and specifically the third last line of that paragraph, where you say attacks and disruptions are continuing and the situation can neither be described as stable nor under control. Do you see that?
Yes.
And this remark is made, Mr. Jamison, in the context of you describing the violence that had occurred at Lonman and the intimidation of workers who want to report for duty. Isn't that correct?
Yes, as described to me.
That's right, as described in the email. Now, what we see from this is that by midday, 1 o'clock on the 12th of August, you took the view that the situation at Lonman can neither be described as stable nor under control. That's correct, isn't it?
Yes.
And you say further, in the second last line of that paragraph, we simply do not have the capability to protect life and limb. Do you see that?
Yes.
And you ask that they use their influences over the necessary officials with the resources at their disposal.
Yes.
But what you're clearly telling the officials in the DMR in this email is that the situation at Lonman is not stable, it's not under control, that Lonman is unable to protect, Lonman does not have the capability to protect life and limb, and that you therefore need external assistance.
Yes.
So while we're on the 12th of August, can we look at quadruple V 1.3? It's the next page of this bundle. This is a media release by Lonman on the 12th of August 2012. Now I'd like you to look at the 6th paragraph of that media release. And in that, the following is stated: at the commencement of the unrest, Lonman immediately took appropriate precautions from a security perspective, including mobilizing additional resources. Do you see that?
Yes.
And to your knowledge, was that an accurate statement? Did Lonman mobilize additional security resources at the commencement of the unrest at Lonman?
Yes, I can remember Frank saying that, Frank Rusabella, who was standing in for Mark Monroe, he was describing on one of the calls, and I can't be entirely accurate whether that was the 10th or the 11th, sorry, the 11th or the 12th. It was probably the 11th, which was the Saturday, I think. That additional resources had been asked for from Natasha. Rian Blignot was standing in for her. So there's two separate security departments, and he had got some from there, I think. and also for some external.
But are
I'm
you
not sure
able
who
to
the
give
service
us-
provider is.
Are you able to give us any further detail about the additional resources brought in specifically from the 10th of August onwards?
No, when I was writing this and reading this, I'm at home in Johannesburg.
Now, we know from the reports of intimidation and from the content of many of the emails which are included in Lonman's bundle that Lonman management was well aware of the widespread intimidation faced by its workers who were trying to go to work during the strike.
Yes.
That's correct, isn't it?
Yes.
And they were therefore aware of the danger faced by Lonman workers who were trying to go to work.
Yes.
And they were also aware of the ongoing threats to the lives and safety of workers reporting for duty.
Yes.
And so, in view of this, Lonman management would have been aware of the need to be careful about calling on workers to report for duty in view of this inherent risk and serious risk associated with reporting for duty.
Yes.
Now, let's look at page 23 of quadruple V1. This is an update by, I think it's Tanya Chikanza. Isn't that's correct, isn't it? If we look at the email before that from Roger Phillimore, which is dated the
Yes.
14th of August, 4:28 p.m., he
Prepared
says,
by
"Dear
Tanya.
colleagues, I attach a note from Tanya summarizing the current situation at the mine."
Yes.
And the update is what appears at page 23, where Ms. Chikanza says the following, and I specifically want to refer you to paragraph 7 of that update. She says, "Management has been monitoring the situation closely in order to decide when it is safe enough to instruct the workforce to return to work." Do you see that?
Yes, the second sentence?
And she says that instruction to return to work was issued this afternoon.
Yes.
Now, do you know when the update was made?
This update?
Yes. We know it's attached to an email from Mr. Phillimore dated the 14th of August. But do you know, specifically, I'm trying to understand, when did
when did this
management
refer to?
decide that it was safe enough to instruct workers to return to work?
What I can recall is that Tanya sent around some emails with some drafts of this, and she asked everybody, who was the people at the mine, particularly the three EVPs and Frank Rusabella was a VP and A.B. Kotler was VP, to update this in readiness because Roger had asked her to do this. So there were some, I can recall, in maybe the day before or maybe it was on that day, that this did the rounds just to make sure that it was correct for her
Yes.
purposes. So when it refers to, is that what you're asking me? When does this 1 to
Yes.
8 refer to, or when does 7 refer to?
Specifically 7, when does that refer to?
No, I don't know.
Statement update was clearly issued on the Tuesday, because it talks about, in the first paragraph, about what happened yesterday, and what happened yesterday also, which is the 13th, of course, involves the killing of amongst others of the two policemen.
Yes.
That's in the second sentence of para 1, is referred to as having happened yesterday afternoon.
Right.
So that means this is issued on the 14th. If you go down to 7, it says that instruction to return to work was issued this afternoon in the past tense.
Right.
So it's either issued, so this document is either drafted in the course of the afternoon of the Tuesday or possibly the evening. But it's clearly done on the 14th. And it was, in fact, we've got the answer. If you look at 22, Mr. Phillimore sends this email to various people, including, he didn't send it to you, but he sent it to various other people. And it's at 4:28 p.m. So Tanya had already prepared the note. So it's clear from the sections I referred you to that this document was prepared in the course of the afternoon on the Tuesday,
Right.
before 4:28 p.m.
Right.
So
that would be my recollection of the sort of markups or the draft that had come round to be checked that it was factually correct.
Yes. But that instruction to return to work, says paragraph 7, was issued this afternoon. So that's already been issued. Right. And so therefore, it seems that management had decided that it was safe to instruct, or safe enough, I don't know what the enough means, safe enough to instruct the workforce to return to work. When was that instruction given, do you know?
I don't. It would have been a decision, Mr. Chairman, taken between, I would guess, Mark, Natasha and Barnard at the mine.
Are you going to put to him the reference in the occurrence book to the radio broadcast?
I am, Chair.
Yes, all right.
Because, Mr. Jamison, what we know is that Lonman would not have encouraged workers to come to work had it not been confident that it was safe for the workers to report to work. That's clear from the update, isn't it?
Right.
And that to do so in circumstances where Lonman was unable to adequately protect the workers would have been reckless.
Yes. Given the timing that I see, there was 800 to 1,000 police on the property. So I would infer that was the reason why it was given, because it was then thought it was safe.
And that was by the 14th.
Well, the first paragraph says that there's 800 to 1,000 police on site.
Yes, and do we know when did the police come to Lonman, the 800 to 1,000 police?
Well, it was certainly by 14th of August.
By the 14th of August. Now, can I ask you to look at quadruple E19?
Oops, sorry. Which page is that, please?
If we look at the entry, sorry, it's the occurrence book. I don't think you've got it before you, so we're going to have to rely on the technician. If we could put up quadruple E19. Now, just to recap before we look at the specific insert, Mr. Jamison, at this stage, in terms of the letter you sent out to the DMR, it's clear that there was Lonman, the situation was unstable and out of control at this stage. There's widespread intimidation.
Yes.
Now let's look at the entry against 740 on the 12th. On the 12th of August.
It's going to take some time because I was proposing to take the lunch adjournment now, but if we can see it immediately, we'll look at it. Otherwise,
I'm going to proceed immediately. It won't take long just to round it up.
so you can tell me when it's appropriate to take the adjournment.
I'll do so, Chair. If you look at the entry on the 12th against 740, you'll see an insert, Mr. Jamison, that message broadcast through Radio Mafisa and Northwest FM that people should go back to work. Now, do you have any knowledge of this public broadcast that people should go back to work?
I haven't got the entry yet.
Problem, we have seen it before, and there's reference to broadcasters on the local radio stations telling people to come to work.
Right. Yes.
And that was on the Sunday afternoon, late afternoon, I think. And we know that Mr. Mabebe was, we don't know whether he heard the broadcast, but we know he went back to work that Sunday evening. He was murdered at K4.
Right.
So it wasn't safe enough for him to go back to work. Others at K4 Shaft were injured. Mr. Langer was on his way to work the Monday morning about 3 o'clock. He was murdered. All after broadcasts had been made on behalf of Lonman, telling people to go back to work. That's the thrust of the point. But can we get the...
May I just clarify, 'cause you were referring to a radio broadcast on the 14th, and you were referring to...
she said the 12th. Am I right? The 12th, sorry.
That's correct, Chair. I think it's up on the
12th.
screen
We've
now.
now got it on... You see 7:40? This is on the 12th. This is in the morning, as a matter of fact. If you go against the number 7:40, there's a line beginning chopper was used. You go 3 lines below that, message broadcast through Radio Mafisa and Northwest FM that people should go back to work. Now, this is against the background of various things that had happened. And certainly, if a message was sent out to people to go back to work, because it's regarded as safe, later that morning, on the 12th, we know that the 2 security guards were murdered, which would seem to indicate that the premises were not safe enough for people to go to work. Now, let's assume that that broadcast was made on the instructions of London, who believed in good faith at that stage that the situation was under control. Surely, when 2 people were murdered in the circumstance which they were, they arrested a heavy duty on London to contact Radio Mafisa and Northwest FM and say, disregard our previous communication. Workers must not come to work until we can give them the green light. Isn't that right?
I wasn't aware of that entry. I wasn't aware of the radio broadcast. So that, if that answers that part
But
of
do you
the
agree with the proposition I put to you?
Yes. Yeah.
And if you'd known that broadcast had been made, would you have strongly urged on your colleagues that steps should be taken to, as it were, render it inoperative, to cancel it, to send the opposite message to the workers?
Well, I wasn't particularly aware of that radio broadcast. That's what I said.
So I say if you had been.
And this email that I wrote before the conference call, which was on the Sunday. So the conference call was after this. So me writing the email that you referred to the DG was based on the security reports. There were some briefs that were sent out by Frank. And if I recall, I also spoke to him early in the morning, or sometime before the conference call, Mr. Chairman. And so my email was based on that, not after. But regardless, even on the conference call, I can't recall anyone saying that there'd been an instruction issue to come back to work, or there was a radio broadcast.
You would agree, as a senior official in London, that those who knew that the radio message had been caused to be broadcast,
yes,
should have responded or reacted in the way I put you.
Yes, I would agree to that. I also know that the management out there on the mine was being urged to, agree to people coming to work, particularly by NUM.
Now, do you know whether any broadcast took place after the broadcast referred to in this entry in the occurrence book, cancelling the instruction that people should go back to work? Any broadcast at all?
No.
From then on?
I wasn't aware of the first one, and I wasn't aware of any subsequent ones. Yeah.
All right. Is it appropriate now for us to take...
I just have 2 questions.
All right,
and
you
then
can
it
ask me 2
rounds off
questions. We will not resume at 2:45, then we'll resume a little bit later. But,
Mr. Jamison, Mr. Sinclair candidly testified before this commission that London Security did not have the capacity to protect all workers who were asked to come to work. Now, in those circumstances, and I ask the question specifically because today, Mr. Sinclair, Mr. Lange's widow is in attendance at the commission. Now, I'm not sure if you're aware, but Mr. Lange was killed on his way to work in the early hours of the 13th of August.
Yes.
And he was brutally killed.
Yes.
The question that I want to ask you is whether, in view of the fact that there was widespread intimidation, there was widespread violence, there were direct threats made against people reporting for work, in view of the situation which you have described in your email, which was out of control, unstable, Mr. Sinclair conceding that London Security did not have the capacity to protect all the workers. was it not reckless for Lonmin to actively pursue workers to come to work, or even to desist from actively discouraging workers to come to work?
In just dealing with the documents we're dealing, in this circular by Tanya and in the previous drafts, I can recall that she questioned that approach. It may have been on this one. There was another release, I think, on the Sunday. There was a press release on the Sunday, I think, and she did question that. And I believe it would have been discussed, although I wasn't involved in it, but by Mark and Barnard and Natasha out at the mine, or Ian and Frank, sorry, get mixed up when they're acting. So that they would have taken all of those things into consideration, I'm sure, and came to the decision they came to. So when I wrote the email to the DG, what I'm saying is it was related to me, and I was asked if I would put the email together, and that's what I did. So it's not my direct knowledge of what was being discussed, only what was said on the call.
Mr. Jamieson, who would have ultimately taken the decision that the workers should be encouraged to go back to work?
I can't say ultimately, but the people who were there that day were Frank. I don't think Natasha Fillion was there. I think it was Rian Blichnow at that time, and it was Barnard, AB. They were there. Whether they phoned Ian or not, I don't know.
Yes, thank you.
Yeah.
Chair, is this a convenient time?
Adjourn now then until 1:55.